Annie, let me start with you. Does she deserve the $75 million, and what can we expect today?
Well, she's not going to get the $75 million. What we could expect here is lots of tears and emotions on the stand. She'll likely talk about the impact that this has had on her and her family. She'll start with the time that she discovered the incident, to the embarrassment that it's caused her and her family, to psychological counseling and any medications she's taking, not to mention the 17 million people who have so far viewed this video. On the other hand, Marriott is going to argue that they're not liable here. This is some lunatic stalker who got this private information because he tricked the hotel employees. However, this is going to be a poor argument. They're going to be stuck with liability here because they had a duty not to disclose her information, let alone giving her the room number and placing him in the adjacent room. What's going to happen here is they're going to say, look, no publicity is bad publicity here. And it's going to be the classic argument that, you know, she got more famous, she had more opportunities, and guess what? She's added a new gig. Yeah, she's added a new gig to her resume, which is Dancing with the Stars.
Well, Annie, you mentioned that. A lot of people are saying that she's gotten more famous because of this. But watch this. We're going to show you some emotional testimony of her dad in court because the hotel somehow allowed him to get the room next to her. What happened?
Yes, well, basically he went over there and tricked them. They say that he tricked them into giving the hotel information. But guess what? It was their duty. I agree that they shouldn't have given the information, let alone the fact that she's a public figure. They placed him in the adjacent room. Over here, it's going to come down to what the jury says. I think that she's going to win on liability. I agree she will. But it's going to come down to whether they think the $75 million is a reasonable number. Given the circumstances in this case, I find it very hard to believe that they'll give her anything in the ballpark of $75 million. They're going to be sympathetic to her cause. Right. But at the same time, she's breathing, she's walking, she's flying across the country, and she has 2 fabulous jobs.
All right, thanks so much. Annie Udine,
it's great to see you this morning. Unanimous verdict over here.
And the father even said, listen, if this guy really wanted to do my daughter harm, he could have killed her because he was right next door. He had a peephole through the door. So, you know, now Erin Andrews is living with this for the rest of her life. She has to consider security. What about that $75 million mark?
First, it has to be intentional and reckless by the hotel. The conduct has to be outrageous, that it wouldn't be tolerated by a reasonable person, and it needs to have serious, serious mental injury. I don't think in this case it's going to be serious mental injury. I think she will win on her invasion of privacy claim because she does have a reasonable expectation of privacy in her hotel room. But in terms of the emotional distress claim, she's going to have a hard time proving $75 million in damages.
Annie and Kent, great to have you both. Thank you very much.
Thanks for having us.
More on this, Annie Azadian is a civil attorney. She has represented Fortune 500 companies in class actions in the past. Annie, thank you for being with us.
Thank you for having me.
Let's just get to the heart of the matter if we can. The science in all of this is inconclusive. So is the issue here the potential risk and the failure by Johnson & Johnson to warn consumers of that possible risk?
Yes. So Johnson & Johnson knew about the risk associated with talc in their product. They use it in their baby powder and their talc powder products, and they failed to warn consumers, even though they knew as far as the 1980s that this product could potentially cause ovarian cancer. I mean, there was a study in 1971 that found 75% of tumors, ovarian cancer tumors, to have talc embedded in it. So this isn't some novel news that they just discovered. They knew about it and they failed to warn, which is their basic duty to their consumers.
Beyond their basic duty, I mean, their watchdogs set up, their councils that are meant to oversee this kind of thing to make sure that companies can't, manipulate the system. I mean, how is it that given that all the data existed, they weren't required to warn the public, even of the possibility?
Exactly. The, ovarian cancer is a bit different. One would argue, I'm not a medical expert, but ovarian cancer is hard to detect, and because it has no symptoms. So these women had developed ovarian cancer because of this, and it took years for them to actually link it to this actual talc powder.
Yeah. Is this getting to something like cigarette smoking where...
I was just going to point that out. It is very similar to the cases that happened years and years ago, which were huge. But I would say that from a shareholder standpoint for Johnson & Johnson, they are looking at shelling out some serious money because there's thousands of cases filed in the United States and more will be filed. And not to mention globally cases are going to be filed because Johnson & Johnson is sold throughout the world. So they have to really evaluate what the claims are and what they're going to do in the future. They can't continue not warning because that's their current stance, that they think that their product was not the direct cause, even though the jury found that it was, and that they could continue not warning.
What's the chain of liability here? Because some of the suits also name like a mining company that actually mines for talent. I mean, where do you see, does it stop with Johnson & Johnson? How far does this net extend out?
No, the suit is about Johnson & Johnson using the talc.
Well, this one is, but in some of the others, they've actually named other parties. So I'm just wondering, from a legal point of view, can you go beyond Johnson & Johnson?
Sure, but in this case, I mean, in a 2013 case, actually, Johnson & Johnson was sued, and they won. I mean, they lost. The plaintiff won. But in that case, they also filed a suit against another company. They lost on those grounds. So they're directly held liable because they're the ones that are putting a product out into the market and have the duty to warn. The other parent companies and associated companies don't have that direct duty that they do. So this is why this is such a huge verdict. It's a statement verdict that's supposed to tell companies, you know, hey, if you know your product could be a potential threat, which could cause cancer, we're not talking about a small medical condition like asthma or athlete's foot. We're talking about ovarian cancer, which could lead to death. You have a duty to warn, and that's what they didn't do.
Johnson & Johnson will obviously appeal this. I mean, I don't think they've formally said that they will, but clearly it's a big company. It's got a lot of money. And I'm just wondering, when you look at this case in particular, and some of the comments I've read online, it took the jury only 4 hours to come to a decision. It was a 3-week-long trial. Right. I mean, some of the comments are, this was basically a rush to judgment. You know, it was a runaway jury. They were out to get the company. They wanted to vindicate this woman.
I disagree. I disagree. The evidence here was just dire. They had an internal investigation that was done in 1997. It was through an independent agency that was reporting to a regulatory body. They found the risk right then and there, and they said that they were supposed to warn the consumers, if not remove this product.
In all of this, was that the smoking gun?
Yes. Okay. Yes, and you know, when you're talking about an appeal, yeah, there's a chance that it might be appealed because of, you know, the causation link and the disproportionate damages here. We got to understand that $62 million was in punitive damages, which means punishment damages. But when you really look at the evidence, it was very, very dire.
Okay, Annie, thank you for coming in.
Really
thank you for having me.
Thank you. It's a very distressing story, actually.
It is, especially for women.
Thank you. Appreciate it.
Annie, you do think she has an argument. You think that she has a case against the school. Why?
I do. On the one hand, this is a politically charged decision. I'm going to admit to that. We saw an outcry from legislators and the media calling for her termination, even asking for a reduction in school funding. On the other hand, her behavior was unbecoming for an educator. That's true. But her appeal stands on good footing here if she is able to prove her allegations that the school didn't follow their set internal rules and regulations to conduct an investigation.
She's calling for muscle over here. The school said that was the nail in the coffin. She's asking for basically violence against one of her students.
Well, she agreed that she was out of line and she apologized for it, but that has nothing to do with the fact that she was fired without conducting a fair investigation. Her supporters argue that according to school rules, a complaint must be filed in order to launch an investigation, and no such complaint was filed over here, yet the school unilaterally undertook the investigation, not to mention...
You have to admit, it's very strange to see a professor acting that way and getting so involved in a student protest.
In the face of growing protests over alleged racism on campus, I heard that Occidental College, they want that president today to step down. That is President Obama's school for a couple of years. On Wednesday, protesters created a black-only healing space. They asked white supporters to leave activist Jonetta Elzie. She tweeted, black-only healing space for the students to share, decompress, be vulnerable, and real.
I don't think it's racist. I think it's hypocrisy at its finest. When these white students are trying to support you and raise awareness and you're essentially kicking them out, it's just you can't preach something that you can't follow. I don't think it was necessarily intent. I just think that he has no respect for women. Of course, he gets prostitutes. Everyone knows about this for, what, about 20, 30 years he's been getting prostitutes. And it's going to be really difficult to prove intent in this case. I mean, we just know about his history, but you know about Charlie Sheen. He's not some C-list actor. You assume the risk when you slept with him that there might be a possibility that he has HIV.
Yes, ma'am. Yes, ma'am. Dominique Singleton says the teacher mistakenly thought she called her a vulgar name. The student was suspended. The teacher was put on administrative leave.
I think that if it was a reasonable threat, she should have maybe protected herself by defending herself and then gone to the proper authorities at the school. I don't know, maybe
Get out of there.
police officer. But I mean, she's a 7th grader.
Yeah, that's crazy.